Welcome to this final chapter regarding the Basic Contracts Act and the Basic Contract Formulation Rules. We are now moving into the subject of invalid contracts. If all the other conditions have been met, we've had the offer, it's been accepted within the period for acceptance before the deadline. If, as often is the case, concluded by agents, all the rules of the agency chapter has been met as well. We are within the authority and so on and so forth. Still, something may go wrong because for one of many reasons, the contract may be rendered invalid. So that is the topic we're going to touch upon here, or at least a fraction of it. It's actually a very huge topic, but we will look at the core of invalidity. We're in the third chapter, third section of the Contracts Act about invalid declarations of intention. And one might get the idea that here we're going to learn everything worthwhile in this relation, but that is far from the case. Actually, I think by far the most rules about invalidity these days are in the various special acts concerning consumer contracts. Various acts governing specific areas of contracts and predominantly within the area of consumer and consumer protection. By far the most rules within this area of obligations between private parties is governed by unwritten law. So whenever you need to change something in that, you can't just rewrite the law because it hasn't been written. So actually you have to impose a new law in this system. So these specific laws on various areas of consumer contracts are the result of this situation. So we're going to focus here on the basic rules in the Contracts Act and a few others as well. So the avoidance factors, or vitiating factors as they're called as well, are divided into two categories. The ones where the avoidance or the vitiation is related to the formation of the contract. Something has not been correct in the surrounding circumstances when the contract was initially negotiated or entered into by the parties. And also, in many cases, it may have something to do with, that's the other category, the content of the contract. Something is unreasonable to quite a significant extent in order for this to take effect. It's unreasonable because of the content, unreasonable content of the contract, it is rendered invalid. What is more important actually is the division between the strong and the weak vitiating or avoidance factors. That is of major legal importance. Always when you're talking about avoidance, you need to address this question: is it a strong or a weak vitiating factor? Because the strong vitiating factors can be relied upon against a promisee, against another party who wants to make good on the promise, even if this person or entity is in good faith. Whereas on the contrary, the weak vitiating factors can only be relied upon against another party who is in bad faith. Quite often, of course, the party who has himself instigated what renders the contract invalid, often because of something having to do with the formation of the contract, he has coerced the other party or something. He, of course, himself will most of the time be in bad faith. And I'll try to explain here how it is noticed and how you can see it in the Act, and also why this difference exists. So as you see here in the Contracts Act, section 28, it talks about coercion, which is administered with threatened imminent violence. So if someone gives you, as it said, I'll give him an offer which he cannot refuse, then it is not binding on the person coerced, full stop. Whereas, in the contrary, in section 29, we have a almost identical situation, and the wording of the section follows the same pattern. Declaration of intention that has been wrongfully obtained, and here not by threat of violence or use of violence, here by coercion other than that specified in 28. This actually may be some kind of extortion, blackmail. Also it says here, is not binding on the person coerced, and then follows here, which it doesn't in 28, a long sentence after the if. So it's not binding on the person coerced if he was induced to make the declaration by the person to whom the declaration was made, or if the latter realized or ought to have realized that the declaration was wrongfully obtained as a result of coercion by a third party. So in other part, he is in bad faith. So in 28, we have a strong vitiating factor can be relied upon against any party, whereas in 29, we have the weak vitiating factor, which can only be relied upon against another party who is in bad faith. So why this difference? Well, it comes down to really is that whereas the coerced party in 28, he has a very good excuse. He can't help himself. He has been threatened, gun to his brain, gun to his head. So he has put his signature on the paper. So he has a very good excuse, you might say. Whereas the other party, he has been coerced by some kind of extortion. Maybe the other party threatened to divulge that he has been unfaithful to his wife, or that he is cheated in tax, or something else which he doesn't want to get out, and because of this he has been coerced. So when you look at the situation of these two coerced parties compared to any third party who wants to rely on the declaration of intention, then you can say that the 29 coerced person, he is himself to be blamed to some extent, which is not the case with a coerced person in 28. So the person in 29, we say, well, he can be blamed himself, whereas the third party in good faith, there's nothing you can blame him. He is innocent in the case, nothing to blame him, so why should he suffer because the other party has been weak and have given into this coercion? So that's the reasoning behind. Moving on to a short presentation of the basic vitiating factors. We have, first of all, false and forgery. This is when somebody forges the signature of somebody else. That, of course, is also a strong vitiating factor, because the person whose signature has been forged, there's nothing he could have done to avoid that. He is innocent. So that's a strong vitiating factor. It's not in any law. That is just, again, one of these things where it's based on tradition. Then we have the violent coercion in 28, which we just looked at. Of course, again, a strong vitiating factor. The other coercion in 29, extortion, weak vitiating factor. Then we have fraud in section 30. And fraud is the situation where where one person tells the other or convinces the other that something is different from what it really is. It has to do with confidence crimes and the like. For instance, I convince someone that a great highway is going to surround his house, and because of this, he sells me the house at a cheap price, too cheap. And of course, it's all a lie about the intersection of the motorway or the highway. This, of course, is maybe not of course, but that is also a weak vitiating factor, because this other party who sold his house too cheap, he should have been more careful. He could have looked out, he could have investigated this further. Exploitation, also a weak vitiating factor. Exploitation is when you exploit somebody else who is simple-minded, who is maybe in dire straits in financial terms. He is lacking money, and you offer him a loan, or you buy something cheap of him in order to support his finances, so to say. So you exploit the other person's detriment to some extent. That is also a weak vitiating factor. Then we have misspelling in 32. That is something which pretty often happens, actually, that in an offer, the offerer will somehow he will make a typing error, or he will make a calculation error, and perhaps offer the wrong price, too low, or he forgot a zero, or whatever the reason may be. The offer or his intentions as expressed will get or will get a wrong content. This, of course, is entirely his own fault. And if the other party is in good faith, it's a weak vitiating factor. If the other party is in good faith, then he can rely on this wrongful offer. So in certain circumstances, of course, it should be obvious to the party receiving this offer that this is too good to be truth, but that is something which, as I say, according to circumstances, maybe not. So it depends on how far away from the normal market price and so on and so forth. Could be anything which really influences this evaluation. Then we have distortion, 32 part 2, is if your message conveying the offer, for instance, your promise, if that is distorted during transmission, not your own fault, not the fault of your agent or employees, but because of in the text of the act, it says by the telegraph service. It's a very old act. So of course, in the olden days, when you dictated a telegram, and this was later transferred by Morse, mistakes could happen. Today is perhaps more difficult to comprehend. But again, it's a strong vitiating factor, and if nothing else, it can serve as an example. Here again, of course, the one making the promise here is innocent. There's nothing he can do to help this from happening. And then we have the rule of general precaution. It's kind of a general clause, a general rule in the entire system of contracts. And we will dwell a little bit on that, and from here on discuss 36 and the whole area of invalidity in slightly broader terms, in order to hopefully give you a better understanding about what this really is about. So we have here section 36. I'll present it as a set-off. Section 36, it says here that a contract may be modified or set aside in whole or in part if it would be unreasonable or at variance with the principle of good faith to enforce it. So this is really far-reaching. You can see the court, as it may be, has here the opportunity to modify the contract, simply rewrite it or part of it, set it aside in whole or in part again. So actually the opportunity here for the court to revise the contract are boundless, you might say. And subsection 2 explains what could be taken into consideration for this. We already heard about principle of good faith and unreasonable content. So here we are in the core of the content validity, invalidity factor. So it says here that in making this decision, you should look at circumstances existing at the time of the contract was concluded. I'll come back to that. And also here terms of the contract, again relating to the content, terms of the contract, and also to subsequent circumstances. So we have circumstances when the contract was concluded, relating to what we discussed already, that maybe something wasn't as it was supposed to be. Then we have the content. If the content is unreasonable, that in itself could be enough, or a combination. And finally, and perhaps most radical here, also subsequent circumstances could be taken into account. 36 arises as a consequence of the developing consumer society from after World War II. Suddenly, all the people who were formerly poor, relatively poor people working in the countryside, they become workers in industry, they earned more money, and society got more wealthy, richer, everybody had more money, and suddenly all these people would now be obliged to enter into much more complicated contracts than they ever had before. Like they would own their own homes, they would maybe buy a car on credit, they would take out loans, they would enter into insurance contracts and the like. Complicated legal contracts about which most of them, of course, had no real skills to evaluate the consequence of. So there were some traders. What happens, that they have taken advantage of this situation in various ways. And in order to remedy this situation or to counter this situation, the courts developed various ways of interpretation, which later were all included in Section 36. So we will look briefly at these ways of interpretation of the contract, which was developed by the courts and the legal science, and because they are relevant, of course, in relation to 36, but also outside 36. 36 is primarily still consumer contracts, not as much as originally, but still. But these principles, they can be used also outside the consumer contract, so they are relevant to all of us. There are three major principles here. The first one here is the principle of conception or ambiguity. And it refers to the fact that a contract, if there is any ambiguities, some unclarity in the contract, then this should be referred to the person or the party who has conceived the contract. So the party who has written the contract, so to say, should any ambiguity should go against him. And this was often the case, of course. We are talking about standard contracts, and some traders may have been tempted to put in some ambiguity in the contract in order to later rely on this against the poor consumer. But then the court developed this principle of interpreting every ambiguity in a standard contract or in the contract which is primarily, of course, conceived by the trader party against the trader himself, by that giving the trader a strong incentive to avoid that kind of ambiguity in the contract. The next basic principle here, minimum rule or doctrine of adoption. So this refers to the situation, again, based on the standard contract, where there is a clause in the contract which is very burdensome to one party in the contract, here, of course, the consumer. So the trader has made the standard contract, and in here we have something which is not attractive at all to the consumer. And the rule here requires that in order for this kind of term in a standard contract to be valid, it must have been the subject of actual negotiation. Often you will see this when you, as a consumer, sign a contract, that the trader will ask you to maybe sign in the margin whenever there is something which might be considered burdensome in order for him to be able to prove that you have been that you have accepted and that you are aware of this clause in the contract. The aim here is that if there are these things in the contract, then the weak party should at least know about it, and he must have entered into this knowingly to some extent. Otherwise, it may be rendered invalid. This, of course, is also debatable because what's reasonable in one situation and burdensome is not in another. So, of course, in a consumer contract, you can have what appears to be burdensome requirements toward the weak party, but in the situation that may be quite reasonable. And you may even have burdensome, or to some extent, who can decide what is unreasonable for another person necessarily. So you can have unreasonable from a certain point of view clauses which are valid, given that they have been part of this negotiation process, and that the trader can prove that this is the case. This is why whenever you on the computer, you press the agree button to a 50-page contract document in legal English without ever having read anything about it. If it's said in there somewhere there was something very burdensome, it wouldn't be valid anyway. So you can feel relatively safe. And then we have the third one, which is related to the issue about subsequent circumstances. Now, of course, this thing about the subsequent circumstances is actually a huge issue. Whenever you enter into a contract, you should, of course, consider everything which is the basis, the preconditions for the contract, and you should consider what might happen to these conditions in the future. If the contract is about the transport of heavy goods, you may put a clause in there that if the price of the diesel used for your lorries, which will do the transport work, if that rises beyond a certain level, then this should be reflected in the price of the contract, and so on and so forth. So whatever might happen, you ought to, in theory certainly, and also in real life, you should try to foresee and, so to say, cover in the contract itself. Of course, this is not possible to always do. Things happen that you couldn't have foreseen, that you were sure about. You didn't have the foresight or the imagination to envisage that this would happen. And that means that sometimes you end up in a situation where subsequent circumstances or subsequently circumstances change, and this renders the contract very unattractive. In these cases, sometimes you can get out of the contract. You can avoid the contract. And it's called in English the doctrine of fundamental breach. So here it is these circumstances which were the basis of the contract which have breached. And in order for this to be rendering the contract invalid, we have three conditions which have to be met in order for this to happen. This condition, which has now breached, rendering the contract unattractive for one party, maybe detrimental to one party, must have been so significant and severe to the party that he would not have entered into the contract if he had understood the circumstances better. So if he had been told that this might happen, then he would have taken his precautions one way or another. Also, the significance of the conditions for the promiser must be known by the promisee. It must be, to some extent, noticeable, obvious to the other party also that this, of course, was an important preconditions for the other party. And finally, perhaps the most difficult condition here is that, according to circumstances, it must be reasonable or relevant to place the risk of this breach of the preconditions with the promiser, with the promisee. See, there's a mistake here in the slide. So it must be reasonable that he should bear the risk of this according to circumstances, and that's often difficult to meet this requirement. Finally, just an ending word. Of course, originally the idea about the contract being binding was very important in business. It still is, of course. That the contract is binding is what makes it attractive to enter into the contract for the parties. They have to rely on that they will get the benefit from the contract which was perceived when they entered into it. But of course there's another thing to take into consideration here also. If we want people to be active in a financial and economic way by entering into contracts, then it may also be quite important that if the contract ends up one way or another being very unreasonable towards them, being detrimental, destroying their business or economy, that then there is an ample opportunity to escape, to avoid the contract. So this is the development in the legal prudence for the time being, and we'll proceed in that direction, I will expect. So that was all about the Contracts Act. We'll move on in the next section. Thank you.